Getting back to the conversation around district number 18 in Texas. We've talked about this district before for those who have followed the channel. Remember that guy, Edward Blum? Now, you may not have heard of Edward Blum, but the way that he has shaken the table over the last 30 years politically has played a role into the outcomes and the impact of what happens to each and every one of us just with our daily experiences. So back in 1992, Edward Blum decided he wanted to run for Congress. And so what he noticed is the 18th district of Texas, which is around the Houston metropolitan area, they had a spot where somebody was running unopposed. There was an incumbent Democratic representative named Craig Anthony Washington. And so Edward Blum decided, hey, that's my ticket in the door. I'm going to run over there. So he runs for office. He loses bad. He only gets 32% of the vote. And with his reasoning, he's like, the only reason I lost is because this district is too black. It's been gerrymandered in a way where there's just way too many black folks and they would never vote for me. So I'm going to sue. Which I always found funny because, again, let's take a picture of what these maps look like, right? When you look at what district number 18 looked like back in 1992, it literally models what our redlining did to Houston, right? So when we're talking about redlining and the conversation around FHA loans and as far as black people not being able to get mortgages from the FHA program, remember, redlining created a space where black people weren't allowed to live in every area. Even if you had the money to purchase the property, you were only allowed as a black person to live in the red areas. Green, blue, yellow, don't worry about it. And it was so crazy where if there was an area that was yellow, it didn't necessarily mean that black people lived there. It just meant that it was in close proximity to black folks. So again, that's going to be a problem. So the desired spaces to live in were green and blue. So when you look at the map of what that redlining did to that region around Houston, and then you look at Houston's district number 18, it mirrors the shape of where the red zones were when it came to redlining. And so what I find interesting is somebody like an Edward Blum has been perfectly fine with benefiting from the end result of something like redlining that screwed over a lot of black people. But when the tables turned and he needed it to work in his favor, now he had a problem with the system. Anyway, he goes and he sues, right? He sues. It goes all the way to the Supreme Court in a case called Bush v. Vera. And he actually wins, right? So now you got to go and you got to redo that map. And so what it does is it gives Edward Blum an adrenaline rush. Like, wow, I'm more powerful than I thought I was. And now that I'm at it, I got a few other things I'm mad about. And so for the next 30 years, this man has gone on a vengeful revenge tour, pretty much against black folks. And so there's been other things that have taken place. He has been a part of more than 24 lawsuits that often deal with the conversation of civil rights. And a lot of times, if he is able to get his way with what it is he's suing for, it tends to be something that works against the favor of black Americans. One of the other big lawsuits that he spearheaded was the Northwest Austin Municipal Utility District Number 1 v. Holder. The purpose of this lawsuit was to gut Section 4A of the Voting Rights Act. Section 4A of the Voting Rights Act aimed to ban discriminatory practices when it came to voting patterns for at least a period of 5 years, meaning outlawing things like a literacy test in order for people to register to vote. Now, this case took place in 2009, and the Supreme Court voted in favor of Edward Blum's lawsuit by a ratio of 8-1. The only person who was the number one that voted against the stripping of Section 4A was Clarence Thomas. Not because he cared about the rights of voters, but mainly because he said, if we're going after 4A, we need to also go after Section 5 and Section 2A of the Voting Rights Act. So yes, I actually support the stripping of this, but we need to look into the constitutionality of these other segments of the Voting Rights Act. It'd be your own people. At this point, he's really feeling himself, so he keeps the ball rolling. Then we get to 2013, and there's another lawsuit that he's behind, which was Shelby v. Holder. The aspect and the aim of this lawsuit was to strip and gut Section 4B of the Voting Rights Act. Now, Section 4B, pretty much, the idea was because at the point in time when we go back to the 40s, the 50s, the 60s, the United States federal government was able to identify different states that had a continued pattern of discriminatory practices when it came to black voters and black voter registration. And so because of that, Section 4B was created, and Section 4B was to identify the states that needed to kind of fall under a jurisdiction of the federal government to ensure that they were not screwing people over when it came to voter rights. And so again, the conversation of, is this constitutional? And so when we get to Shelby v. Holder, this too was gutted. And the argument was, racism is over. We're post-racial. Barack Obama's president. Beyonce sells 1 million records. LeBron James wins a lot of championships and everything else like that. And the black kids, they got their HBCUs that they can go to. And so racism doesn't exist anymore. We don't need this section either. And then Section 4B of the Voting Rights Act was stripped down. And this is when we started to see the increase of voter ID laws and all these random draconian laws like making it illegal to give people bottles of water when they're in line to vote in the state of Georgia. All of those protections are now kind of stripped. So we've seen Section 4A get stripped. We've seen Section 4B get stripped. And again, Clarence Thomas was like, yeah, we can get rid of this part. But again, don't forget about Section 2A and Section 5 because those are important. Now, I've already done a video on Edward Blum, so I'm actually just going to add that in the description for those who want to watch it, and I go a bit more in detail about some of his other lawsuits. But again, his work is not stopped. When we talk about the fact that there have been changes when it comes to affirmative action in college admissions, he was behind that lawsuit. When it also comes to the shutting down of the Fearless Fund, he was behind that lawsuit. Again, Fearless Fund was a startup company that aimed at providing resources to black women-owned businesses when it came to venture capital, where they could get $20,000 to $25,000 grants for their businesses. They always tell us to pull ourselves up by the bootstraps. So then when people in the community get together and try to pull ourselves up and create things, somebody like an Edward Blum shows up and says, oh, that's racist. That works against all the other groups. What about white women businesses? What about Asian women businesses? What about everybody else? And so boom, that was in litigation back and forth in the system. And eventually, Fearless Fund eventually just shut down because of the cost and the conversations around litigation and how expensive everything was. So somebody like Edward Blum has had it out for black folks and it has not stopped. Now, this leads me to my next segment. Supreme Court could be set to end key protection for minority voters. The U.S. Supreme Court escalated the high-stakes redistricting battle in Louisiana by ordering new legal briefings on whether intentionally creating a second majority black congressional district to comply with the Voting Rights Act might violate the U.S. Constitution. The court's order Friday directs both sides to submit supplemental briefs on whether the state's intentional creation of a second majority-minority congressional district violates the 14th or 15th Amendments of the U.S. Constitution. The order suggests that the court's conservative majority could be readying to make a sweeping ruling that creating districts in which minority voters can elect their representatives of choice under Section 2 of the Voting Rights Act is unconstitutional. If the court rejects the idea that the Voting Rights Act serves a compelling interest, it would become increasingly difficult to protect minority voting power. Previously, the Supreme Court has allowed states some breathing room to consider race when drafting districts to comply with Section 2, as long as race was not the predominant factor. The court's move comes months after a federal court struck down Louisiana's remedial congressional map on the grounds that it was an unconstitutional racial gerrymander, even though the legislature passed it to fix a prior Voting Rights Act violation. In Louisiana, black residents make up nearly 1/3 of the population, yet were previously able to elect candidates of their choice in just one of 6 congressional districts. The creation of a second black majority district was widely viewed as a minimum requirement for fair representation. You see how all of this ties together? Now, one thing that I will say, and I'm not one to be an I told you so, for years I've been talking about the fact that Section 2A and Section 5 would be on the docket when it came to the Voting Rights Act. Case in point. And it's only going to get worse. And like I've told you, the Voting Rights Act is still on the docket. Section 2A is on the docket. And if it's up to Clarence Thomas, he will find a way to go after Section 5 as well. He's still making the argument about the constitutionality of Section 5. He's like, now you see how all of this is tied together? When we talk about Texas and the conversation of gerrymandering, the goal is to strip away the power of the black vote, to limit just how much representation is there, as well as gaining seats in the House where they can further push their agenda as far as what they want to do when it comes to the GOP. There's that conversation. There's the conversation of census and the idea that now all of a sudden the Trump administration wants to kick off another census count 5 years early, mainly because they recognize that, hey, we need to manipulate the numbers even more. Let's use the boogeyman of illegal immigrants to justify why there needs to be another census count. Even though when we had census in 2020, the administration decided to cut it short because they recognized that there will be different groups of people who were undercounted, and this would work in the favor of the GOP. Now we also fast forward to what's happening with voting rights acts. And like I've been saying for years, all of that is on the docket, okay? And here we are again, where again, the constitutionality of the Voting Rights Act keeps getting chipped away piece and section by piece by section. And so, again, when it comes to the conversation of race, like I've always said, nothing is precedent. Don't think just because there has been a gain or two that things are locked in. There's always somebody working double overtime to strip it away. And this is why I always say that for years and years and years, the goal has been to cement the nonsense. Understand that if Texas is successful with gerrymandering and redrawing these districts, there is no representation and no power when it comes to the black voice in the state of Texas at this point, because literally all of these districts are going to be red, minus a handful. Like, this is going to be the end of some political careers. Somebody like an Al Green most likely will no longer have a seat in the House. And so these are things to think about when it comes to census. If there are people that are still saying, well, I'm not counting, I'm not doing this, I don't need them watching, seeing what I'm doing. Well, okay, now you're undercounted. This plays a role into what happens politically, because this gives a group like the GOP an opportunity to gain more seats in the House. Because again, they can take care and do what we said as far as manipulating the districts when they draw them and making sure you dilute segments and populations where they feel that people may have too much political power that they don't believe in. And so again, then we get to what's happening with the Supreme Court. We already know the Supreme Court has been on some nonsense ever since, you know, the last 3 have been added to the bench. So be for real. Anyway, this is why I say do not tap out. You have got to stay locked in, because they're doing it right in your face. And while you're getting mad about optics and smaller things that don't really carry any weight, they got a whole system and a whole strategy that's bigger than a lot of us can even imagine. And that's why I say pay attention.